Mr. Dreeben, let's say that we don't want to say that this statute protects just common law Blackstonian property, as you propose in your brief. Could we decide that the right to control assets isn't a sufficient basis for the prosecution another way, maybe by saying that they're conflating, that the government is conflating the materiality element with the intent to defraud element, and that way not have to decide cases that aren't before us about other, bundles, sticks in the bundle of property?
Well, Justice Barrett, I think that there are a number of ways to conclude that the right to control theory is invalid. Your Honor pointed to one. It tends to merge different elements, not only materiality, but the way that the Second Circuit has described it. It also subsumes intent to defraud. And by collapsing all those elements, it violates core requirements of the statute. It also tends to run aground because it infringes on turf that's covered by Skilling and McNally and would allow the government to prosecute a variety of kinds of things through the guise of calling them property fraud when it cannot do so under honest services. And I'm not saying that the two are hermetically sealed worlds, but the way the government has treated right to control in the Second Circuit, it fills in the blanks where the honest services doctrine got cut off by McNally and not reinstated by 1346. So the court could also say Congress reinstated certain intangible rights in the Honest Services Amendment, Section 1346. The right to control assets is not one of them, and therefore it does not qualify as property for purposes of the property fraud statute.
And you don't see any problem with any of those routes?
I think they all cumulatively reinforce each other, and the court may wish to take this opportunity to say what it has already said in Cleveland and in Carpenter, which is that the wire fraud and mail fraud statutes protect traditional property interests. It does not have to map what every traditional property interest is today. This is not a case, for example, about intellectual property. It's about a made-up right to information that bears on an economic decision. That has no roots in the common law. I think the court can at least say that without prejudicing the government in arguing for other kinds of property, whether exotic or traditional.